The next case to come before the court is S. Wentworth Anthony et al. v. Sareesce. I'm going to put that right. Sareesce Groves et al. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of the time. The argument, would you like to 5 minutes?
Yes, thank you.
Very well. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children or minors or victims should that be included in your argument. You can refer to those folks as initials, with initials or terms like the child, though that probably isn't relevant here. The judges have read your briefs and are ready to proceed when you are.
Thank you. Good morning, Your Honors. My name is Honey Howard Rothschild, and I represent the appellant, Angela Camille. May it please the court. The lower court granted appellee Sareesce's motion to dismiss under Civil Rule 12b-6. Angela had filed a complaint for forcible entry and detainer, and her second cause of action was for unjust enrichment for unpaid rentals. And it's well settled that the standard of review for this court for a 12b-6 motion is de novo, for you to do an independent review of the case to determine if the dismissal was lawful and appropriate, which of course Angela claims it was not. What started out as a simple complaint for a partition of a house partly owned by Wentworth Anthony, who sold his 1/4 share to my client Angela, has resulted in 3 years worth of contentious nonsense in the common pleas court that has ended up here. How did that happen? Every morning when my eyes pop open, I ask myself the same question. And now I will attempt to unravel it all for you to understand and decide the issues in favor of appellant, who asks the court to reverse the lower court and to remand the case to the lower court to set a hearing on Angela's second cause of action for unjust enrichment to recoup the unpaid rental that was for 8 years at the time she filed the complaint, but now it's 9 years, against Sareesce and her husband Marlon. Marlon was also served with a complaint, but he failed to appear without any explanation at the July 15, 2022 hearing in the Lorain Municipal Court. During that hearing, appellant Sareesce testified under oath that her family had occupied the property. Up to that time, it was 8 years. Of course, now it's 9 years because that was a year ago. They occupied it rent-free because she claimed to be the owner of the flat. But however, the facts proved that they were merely guests and squatters. What does that have to do? What does this eviction case have to do with the partition case? Well, during the July 15th hearing before the magistrate, the court took judicial notice of the partition case. And you can see Angela's affidavit of the evidence at page 4, paragraph 6, that went unopposed or contested by the appellees. And therefore, the court determined that plaintiff's characterization of the hearing conducted before the magistrate is accepted. Furthermore, Sareesce testified that her father, who co-owned the property with Angela, had given up possession and gave her ownership of the house. And Sareesce ratified these documents from the partition case, where she swore that she was never a tenant, that she never had an obligation to pay any rent and had never paid any rent, and that her father had given her the property in exchange for her paying some back taxes on the property.
Was there an actual quitclaim deed?
I'm sorry?
Was there an actual quitclaim deed? Was there a deed actually transferring the interest of the property?
Yes, there is.
And that's in the record?
Yes.
So the appellants, not the appellants, the appellees that are actually co-owners with your
Oh, no, I think I misunderstood your question. The appellant had bought the property from Anthony. The original partition case was brought by Anthony and Tacoma Police Court. And during those proceedings, Anthony sold his 1/4 interest to Camille, Angela Camille, who is now the plaintiff in the eviction case, and is now the appellant in this case.
I thought you were saying that Sareesce's,
She claimed to be an owner,
that's what I'm saying.
but she was just a tenant, she was a guest.
Okay.
She claimed
There
to
was
be,
no transfer of property.
right, there was no transfer of property to her. It's just that her father gave her possession. She and her family lived there exclusively and had control of the property, and they even barred and prevented Angela or Anthony from coming onto the property claiming that they were the lawful owners, even though as you just heard in the previous case about adverse possession, even though they had only been in the property at the point that the eviction notice, the eviction case was filed for only 8 years. As you know, adverse possession requires 21 years. So they had no lawful claim. Meanwhile, Sareesce's father kept fighting the partition case, although there was never any objection or challenge made to the preliminary judicial report in that case, in the partition case, that stated that Anthony was the owner at the time. And later on during those proceedings, the title was transferred to Angela, and she became the lawful owner by deed from Anthony. And that was part of the partition case. And also, Sareesce acknowledged that during the testimony at the eviction hearing. Anyway, this case, the partition case has been going on now for 3 years, and there have been so many continuances on the part of the defendant for a case just on the issue of partition was never disputed. Because as I said before, the preliminary judicial report was never objected to or contested by the other side. The question was now, what can Angela do? Because the house, she went over to the house just from the street. She was never allowed to set foot on the property. But she saw the house was falling apart, the downspouts and the tiles were falling off the roof. And there was a person, family living in the home who were not paying rent, so there were no monies to keep the property, to do any kind of repairs. And she was not allowed, neither Anthony nor she were allowed into the property, which is a violation of a fundamental right of an owner under common law to go in and inspect your property. Because as we saw in the last case, I just heard the arguments about, if you don't go in and inspect your property, you don't know what's going on. Aside from the fact that recently, in the partition case, Angela was allowed to get in and inspect the property and discover some dangerous conditions, not just electrical wires hanging, but the other side are breeding pit bull dogs, in which case that's a very dangerous condition. And if even the Sareesce's own children got injured or killed, Angela would be sued.
Counsel, is that in the record though?
Well, the thing is that the court took judicial notice of the partition case. So anything that's happening in the partition cases should be part of the record. It didn't happen until last week, 2 weeks ago.
Well, anyway, what I'm asking is that partition case though in our appellate record?
I'm sorry?
Are the filings in the partition case part of our appellate record?
Well, some of the documents are.
Okay, some are and some aren't.
In the plaintiff's affidavit of evidence, there are some documents from the partition case wherein Sareesce and her father notified the partition case court that she had exclusive possession. She was not a tenant, she was an owner. And this is the evidence that we presented in the eviction case, that we were not trying to evict a tenant, we were trying to evict someone who was on the property claiming to be an owner, who wasn't paying rent, but who was exclusively occupying the premises to the, and excluded the real owner, who was Anthony and Angela. They were not allowed to come onto the premises until a couple of weeks ago. While the other side has been in possession of the property for nearly 9 years, Angela was allowed to get on the property for like a couple of hours. And here she is an owner who would,
And counsel, just to be clear, you say here she is an owner, but she wasn't the only owner, correct?
well, she was not the owner in the beginning. What the thing is that the other person who owns the property was Sareesce's father, who is 3/4 owner, and he is the one who gave abandoned his possession, because he allowed her to go in there, renovate the house, stay in there, and block Angela or Anthony from either coming in to inspect or to do an appraisal.
So he was the co-owner?
Yes, he
of
was
the
a co-owner.
property.
Her
And
father's a co-owner.
Why isn't your client's resolution then action against them? Why wouldn't it be, recovery would be against them?
Well, there are two answers to respond to that one. The partition case is to, at the time that Anthony brought the action, he wanted to sell that, to have the house sold, and in that instance, hopefully, Sareesce would be evicted, and then he could get in a real paying tenant. The other thing is that the case has been so contentious, going on and on and on. There's a hearing next week, but I know they will appeal, because in the beginning, her father vowed that we would never get the house, never be able to sell the house. That case can go on for years. They can take it up to the Supreme Court. Meanwhile, the house is falling down and be worthless, and those dogs could bite somebody and kill somebody. And Angela would be responsible. But the other
Counsel, I do want to let you know you're moving into your rebuttal time.
Okay. Well, anyway, so basically, we believe that the basic issue in here is possession. And the co-tenant, it is well settled that a co-tenant cannot dispossess a tenant of a co-tenant. However, they claim never to have been tenants. They're not tenants, they claim to be owners. In which case, the court below erred in dismissing the eviction. And they also erred in dismissing the unjust enrichment cause of action for unpaid rent. They were able to use the property all these years, and also for damages.
Thank you very much. You will have 4 minutes and 20 seconds for your rebuttal. You may proceed.
Thank you. Good morning, Your Honors. May it please the Court, my name is Christopher Mulvaney, represent the police, Sareesce and Marlin Groves. Appellants Camille raised primarily the issue of, it appears, whether or not the Groves are tenants or somehow guests or squatters in the house in question. As a preliminary issue, they are barred from raising any of those issues in the trial court at trial because there was no claim for non-color of title or unauthorized occupants on the 3-day notice that was posted to the property. The 3-day notice that was posted solely listed for grounds non-payment of rent. So the only grounds under well-established case law that they could proceed at trial would be on the basis of non-payment of rent. The initial magistrate's decision, which addressed that issue, we did point out to the appellants that they could have simply served a new 3-day notice listing non-color of title and proceeded on a different eviction had that been the route they wanted to take. With regards to the issue of whether or not the Groves are tenants or squatters or guests, however they want to characterize it, however they themselves may have characterized it, whether Sareesce Groves characterized herself as an owner or not, is frankly irrelevant because they're lay people, they're not legal experts. What matters here is whether or not they were occupying the property pursuant to an agreement with Robert Woolbright, the 3/4 owner of the property. And I would note that in the objection to the magistrate's decision on page 2, plaintiff's affidavit of evidence, page 4, paragraph 6, appellant's brief, page 7, and on the amended complaint, page 1, Camille expressly states that the Groves were occupying the property pursuant to an agreement with Robert Woolbright, where they would pay the taxes and take steps to maintain the house in exchange for their possessory rights.
Counsel, you mentioned the magistrate's opinion and the objections and so forth. It made me think of an issue that I noticed when I was reading everything, and that is, the magistrate said that it was dismissed without prejudice, so that they could refile, because he said that they got the notice wrong, not necessarily wrong, but they only alleged one thing, so they could refile. Did the trial court just accept that, or did the trial court dismiss with prejudice?
I am not entirely sure what the posture was on that, because the initial decision was adopted, magistrate's decision was initially adopted by the trial court, followed by the appellant's objections, which resulted in the second decision by the trial court, which granted the motion to dismiss. So I was not entirely sure which initial decision was being appealed here, so I attempted to address both of those in my brief. I would state that pursuant to 1923-01C, that the Groves meet all of the requirements to be considered tenants under a rental agreement. A rental agreement is any agreement, oral or written, which establishes the terms and conditions by which a party occupies a premises. The agreement that was reached between the Groves and Robert Woolbright is an oral agreement which establishes terms and conditions. Specifically, they pay the taxes and work on maintenance of the property. So that makes it a rental agreement, which makes Robert Woolbright the landlord and the Groves a tenant pursuant to a rental agreement. So the issue of whether they're squatters or guests is effectively immaterial. To the extent that the 3-day notice raised the issue of non-payment of rent, there was never any rental agreement entered into between Camille and the Groves. The obligation to pay rent is a contractual obligation. There was a demand made by Camille that they pay rent. That was never accepted, and there's no evidence in the record that that agreement was ever accepted. I would just briefly mention the issue about, excuse me, whether or not a default judgment could be entered against Marlon Groves. That I think is immaterial. Even had a trial occurred, in this case, a plaintiff in a forcible entry and detainer action is still required to prove their case to the court. They cannot simply get a default judgment. I would further argue that Robert Woolbright had full authority to lease the property to his daughter under the laws in Ohio. Mr. Woolbright and Ms. Camille, or her predecessor in interest, Mr. Anthony, were tenants in common with a joint interest and title to the property. Each tenant in common has a separate and distinct title, and they hold that title independently of the others. As a result, any one co-tenant can take possession of the property and occupy it and serve to exclude the other co-tenant. In this case, Robert Woolbright had possession of the property, and he granted his possessory interest to his daughter via a rental agreement. And ultimately, what it comes down to is, can one co-tenant forcibly oust another co-tenant? I think it's settled law that one co-tenant is not permitted to oust another co-tenant in possession. Further, the law is, I believe, fairly clear that the possession of a tenant is the possession of their landlord. So the possessory rights that Ms. Camille, that the Groves possess in the property is Robert Woolbright's possessory right. So an attempt to dispossess the Groves is in effect an attempt to dispossess Mr. Woolbright, which cannot be done in a forcible entry and detainer action. The remedy is a partition case, which is already pending and is set for trial next Friday.
And counsel, so your position would be the same, I guess, if Mr. Anthony had given a tenancy to the appellants here, and they were occupying the space. So it doesn't matter whether it's a fourth or a third or fourth, whatever. You know what I'm trying to say?
Yes.
Doesn't matter what the property interests are, the ownership interest.
That is correct. It does not matter what the percentage ownership interests are, any one co-tenant has equal rights to take possession of the property and devolve their possessory rights onto a tenant. I would so refer to the holding in H&H Farms v. Hull, the District Court, Northern District of Ohio. The question boils down to this: does Ohio law permit one tenant in common who has an undivided interest in land to lease the entirety of the property in question without his co-tenant's assent? A review of Ohio property law reveals the simple answer to that question is yes. Further goes on to state that a lessee in possession is, they possess the property on behalf of the lessor. In essence, the gross possessory rights are Woolbright's possessory rights and cannot be dispossessed by a forcible entry detainer action. The remedy is, as mentioned, a partition case. With respect to the second cause of action claim about unjust enrichment, we'll simply note that the damages being sought there are identical to the damages being sought in the partition case, a claim for the value of the rentals. There was a reference made to the issue of adverse possession. I believe it's established that to achieve title by adverse possession, you must show exclusive possession, open, notorious, continuous, and adverse for a period of 21 years. Any possessory interest by the Groves cannot be considered adverse to that of Camille or her predecessor in interest, Anthony, because she has the full right to possess the property that was granted to her through her father's interest in the property. That cannot be considered an adverse claim or use, no matter how she may have characterized it in any prior hearings without any involvement or advice of counsel. Thank you very much.
Thank you, counsel.
Thank you. May it please the court. Opposing counsel has misstated the record. Number one, his motion to dismiss did not mention anything, not a single word about any lack of notice. And the judgment, the final judgment of the court stated that the arguments in the motion to dismiss and the discussion in the magistrate's decision as to the co-tenancy issues are persuasive. There was nothing in the motion to dismiss about the absence of any notice. In fact, the record shows, and refer you to the plaintiff's affidavit of evidence presented at the magistrate's July 15th hearing, September 1st, 2022, to which the opponents never filed any opposition. Attached to it is plaintiff's Exhibit L that proves that on 16 April 2022, Angela and Camille served a 30-day notice to terminate the tenancy to Sareesce. That's part of the record. Nothing to do with that 3-day notice. It was based on the 30-day notice. Aside from the fact, when he was talking about the magistrate's decision, who discussed lack of notice, that was not the final decision, as everyone knows in this case. The final decision comes from the court after reviewing the magistrate's decision, which they can either accept or reject, in which case they rejected it in part. And instead of holding anything at all about the notice, the court based its decision on co-tenancy issues. And the point that this plaintiff appellant is making is that the intent of the parties, including Mr. Woolbright and his daughter, was for her to become an owner. And they manifested that by having her pay the taxes. How many tenants do you know pay the taxes on any property? Tenant pays rent. In this instance, they didn't pay any rent. Many, many years went by paying no rent. They just paid the tax, the back taxes at the beginning. So that was an indication that they were trying to transfer ownership and do indirectly what they could not do directly, because Anthony and Angela were the owners of record. And what they did was just bar Angela and Anthony from being on the property and acted like owners. They even renovated tore out the upstairs apartment. They acted like owners and never once communicated with the Anthony or Angela, although this attorney had sent them requests for accounting through the years, they just ignored it. They act like owners. So the possession, this was just a mockery, a false thing that they're saying, oh, we're tenants. No, but that's not what you told the common police court under oath. Both of them swore under oath by affidavit and jurat that they were owners. She was an owner, not a tenant. That's the issue here. And by common law, they have the right to evict squatters from your property and to stop that clock of adverse possession from running. So therefore, we ask the court if you would please reverse the dismissal and remand this to the court for further proceedings. Thank you.
Thank you, counsel. Thank you both for your presentations. The court will take them under advisement and issue a decision in due course. The clerk of courts will send you a copy of that decision on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again for your presentation.